Be ready. 5 seconds.
Procedural fairness requires that persons liable to be affected by a proposed administrative decision be given adequate notice of what is proposed so that they are not taken unfairly by surprise, and also that they are in a position to make representation against the proposed action. It is legally well settled that mere issuance of show cause notice does not amount to an adverse order which may be held to affect the rights of the parties. The necessity for issuing a show cause notice and the requirement of specifying the grounds on which the action is proposed is in fact a necessary prerequisite so as to ensure that the noticee is aware of the grounds on which action is proposed and has an adequate opportunity to rebut the same. If the show cause notice does not specifically state the grounds on which it is being issued and the proposed action, the noticee would be taken by surprise and would not have adequate opportunity to rebut the allegations during the course of inquiry which is to follow. We are of the view that the challenge to the show cause notices in the instant petitions is premature for the reason that the mere indication of the grounds and the penalty proposed would not give rise to a cause of action, as it is open to the petitioners to present their case and rebut the imputations, whereupon it would be incumbent upon the respondent authority to proceed with the inquiry and pass an appropriate speaking and reasoned order after giving adequate opportunity to the petitioners and ensuring due compliance of the principles of natural justice. The outcome of the inquiry, which is proposed in terms of the show cause notice, would only be a matter of conjecture at this stage, inasmuch as it is equally possible that after considering the response of the petitioners and holding due inquiry, the respondent authority may drop the proceeding or may reject the reasons given by the noticee. It is only upon conclusion of the proceedings where any order is passed by the respondent authority which is prejudicial to their interest, the petitioners may have cause of action to raise a challenge to the same. Having regard to the aforestated facts and circumstances, we are of the view that the challenge raised to the show cause notices at this stage is premature. Accordingly, we are not inclined to exercise our extraordinary jurisdiction under Article 226 of the Constitution of India to interfere in the matter. It would be open to the petitioners to submit their response to the show cause notices dated 18/6/2022 within a period of 2 weeks from date whereupon the concerned respondent authority would be expected to conclude the proceedings within a further period of 2 weeks, after affording proper opportunity of hearing to the petitioners and according due consideration to the defense set up by the petitioners in the replies to the show cause notices and pass reasoned and speaking orders thereupon. The petitions stand disposed of accordingly.